Is this the end of non-competes in the USA? We recently saw the United States Federal Trade Commission vote to institute a new rule as the interpretation of Section 5 of the Federal Trade Commission Act, which bans current and future non-competes in the employment setting, with the exception of existing non-competes for senior executives. The new rule, which is set to come into effect at the end of August 2024, only provides for one permissible employment-related carve-out, which is provided to existing worker non-competes with respect to senior executives who are workers earning more than $151,164 annually, who are in a policy-making position. The U.S. Federal Trade Commission's explanation for this particular carve-out for existing non-competes with senior executives was its determination that this subset of workers is less likely to be subject to the kind of acute, ongoing harms currently being suffered by other workers subject to existing non-competes. Credible concerns raised as to the practical impacts of extinguishing existing non-competes for senior executives. The new rule also contains a notice provision on the employer, requiring employers to notify employees with existing non-competes that they are no longer enforceable. To understand whether this in fact means the end of non-competes in the U.S. employment context, one must begin by assessing the actual language of the rule, so as to determine what is included and what is excluded. The FTC's rule defines non-compete clause as a term or condition of employment that prohibits a worker from, penalizes a worker for, or functions to prevent a worker from 1. Seeking or accepting work in the United States with a different person where such work would begin after the conclusion of the employment that includes the term or condition, or 2. Operating a business in the United States after the conclusion of the employment that includes the term or condition. The FTC's rule further provides that for the purposes of the final rule, term or condition of employment includes, but is not limited to, a contractual term or workplace policy, whether written or oral. The rule further defines employment as work for a person. The FTC's rule defines worker as a natural person who works or who previously worked, whether paid or unpaid, without regard to the worker's title or the worker's status under any other state or federal laws, including but not limited to whether the worker is an employee, independent contractor, extern, intern, volunteer, apprentice, or a sole proprietor who provides a service to a person. The FTC's definition further states that the term worker includes a natural person who works for a franchisee or franchisor, but does not include a franchisee in the context of a franchisee-franchisor relationship. The FTC's rule does not apply to non-competes entered into by a person pursuant to a bona fide sale of a business entity. In addition, the rule does not apply where a cause of action related to a non-compete accrued prior to the effective date. The rule further provides that it is not an unfair method of competition to enforce or attempt to enforce a non-compete or to make representations about a non-compete where a person has a good faith basis to believe that the FTC's rules is inapplicable. The FTC's rule does not limit or affect enforcement of state laws that restrict non-competes where the state laws do not conflict with the final rule, but it preempts state laws that conflict with the final rule. Meanwhile, recognizing that the courts might strike down a part of the new rule, the FTC included a severability clause such that if any part of any provision or application of the FTC's rule is determined to be invalid or unenforceable, The remainder of the FTC's rule is intended to remain in effect. There are already judicial challenges to the FTC's non-compete rule, such that there is already a degree of uncertainty as to its exceedingly broad and expansive application, especially where there may well be legitimate reasons for instituting a non-compete on a particular employment agreement. The judicial challenge brought by Ryan LLC, a global tax services and software provider, contends that would have serious adverse effects on intellectual property protections, talent development and retention, which enables employers to pursue a work culture that fosters innovation and development, without which competitors might hire away employees to gain insights into an employer's internal workings and intellectual property. They argue that it is the rightful interest of every company to retain its proprietary formulas for success taught in good faith to its own employees. Ryan LLC views, among other benefits, non-compete agreements incentivize companies to invest in research and development, empower collaborative work environments, and instill a commitment to aiding personnel growth and development. Non-compete agreements also promote worker training, increasing their earnings by solving a free rider problem that inhibits firms from investing in their employees. These arrangements, mutually agreed upon by the employer and employee, enable all parties to maximize their output in an open and dynamic work environment. Innovation fueled by collaboration is critical to the modern economy. They view one-size-fits-all approach taken by the FTC as upending a long history of evaluating non-compete agreements through case-by-case analysis. The Commission instead has bluntly struck at nearly all existing agreements. The U.S. Chamber of Commerce also sued the FTC with respect to its effort to eliminate most employment-related non-competes, contending that the Federal Trade Commission's decision to ban employer non-compete agreements across the economy is not only unlawful, but also a blatant power grab that will undermine American businesses' ability to remain competitive. The U.S. Chamber of Commerce argues that 1. The FTC lacks the authority to write regulations defining unfair methods of competition. 2. Even if the FTC had such power, the rule would still be unlawful because non-competes are not categorically unlawful, as evidenced by non-competes' wide use and routine enforcement under state law. 3. The FTC's rule itself is impermissibly retroactive to the extent it undoes previously executed agreements. And 4. The FTC's rule reflects an arbitrary and capricious exercise of the FTC's powers by 3 unelected FTC commissioners. As such, contending that this is the end of non-competes in the United States of America would appear to be somewhat premature. The imposition of such a broad and expansive rule, which is not nuanced and that bends over a century of commercial and legal practice by 3 unelected FTC commissioners, still faces a very tough legal road ahead. The outcome of this effort to ban employment-related non-competes is a long way from being settled, with the final result being far from certain. Thank you.